In this video, I'll differentiate between the roles of a consulting expert and that of a testifying expert, the importance of the distinction between the two, and the privileges that apply or don't apply to each role. I know you're busy, so you might want to consider setting this on a 1.5 times speed, and this 9-minute video will turn into about a 7-minute video. The expert witness needs to be very sensitive to the privilege differences in these two roles, because sometimes the client's attorney is unaware of or ignores the differences. The consequences of this omission can be devastating to your involvement as a witness in a litigation matter. In the world of expert witnesses, there are consultants, often called consulting experts, and designated expert witnesses. These two categories are dramatically different, with consequences extending to the strategic core of your litigation case. A designated expert witness is a person who is formally disclosed to the opposing side as a retained expert and is intended to present expert opinion evidence at the trial of the case. The most important thing to know about the designated expert is that all of the expert's work in the matter is discoverable by the opposing side of the litigation, subject to a minor exception that I'll talk about in a minute. But this means the other side is entitled to see all written communications to or from the expert. They can inquire about all oral communications with the expert, all research done by the expert or the expert staff, the analysis, testing, inspections, etc. All of the expert's work and communication is open to discovery. Nothing is protected from disclosure. Let me quickly mention one exception to discoverability of the designated expert's work in the Federal Rules of Evidence. This exception allows for drafts of expert reports and related communications to be confidentially shared between an expert and the retaining lawyer, and shielded from discovery. Other than that exception, the entire workup of the designated expert is subject to discovery. I suggest that you think of your expert witness work as completely discoverable. Now let's compare the designated expert witness to the consultant retained to help and advise the lawyer, often referred to as a consulting expert. A consulting expert is a person retained by the lawyer to assist in the preparation of a case for litigation. Lawyers can hire anybody they want to assist them, a paralegal, a secretary, a law clerk, or someone who has substantive expertise in a technical area that may be relevant to the litigation. The work of these consultants falls within the attorney's work product rule, a privilege that shields everything done by the attorney or her consultant from disclosure to the other side of the litigation. Now, there's often confusion between two different privileges that apply to attorney communications and activities. The attorney work product rule, sometimes called work product doctrine or privilege, protects from discovery documents, communications, and tangible things that are prepared in anticipation of litigation or for trial. The work product rule covers the work and communications of persons other than the attorney, provided the communications and work were done under the attorney's direction and in preparation for litigation. The other privilege that merits discussion here is the attorney-client privilege. This privilege protects confidential communications between an attorney and a client to encourage open dialogue to seek or give legal advice. To qualify as attorney-client privileged, the communication must be between an attorney or staff and her client, made in confidence, and for the purpose of obtaining or providing legal advice. The privilege is held by the client and may be lost if the communication is shared with a third party. Importantly, the attorney-client privilege does not apply to communications with an expert witness or even an attorney's consultant, assuming the consultant isn't the client. But sometimes attorneys or clients think that communications with experts fall under the attorney-client privilege. They don't. And experts should be very assertive in stopping conversations that begin to involve legal strategies or subjects outside of the expert's area of expertise. To the designated expert witness, none of these conversations is privileged. So now I want to talk about some nuances that come up with the issue of privilege relating to expert witnesses. Remember, we're not talking about attorney-client privilege here. That privilege is completely off the table. We're only talking about the attorney work product rule. The first issue that arises involves the person who was originally hired as a consultant to the lawyer. He or she did some preliminary work in the case. The lawyer likes the conclusions the consultant has reached, and now the lawyer wants to designate the consultant as an expert witness. Is any of the now designated expert's work shielded from discovery? No, it isn't. It's difficult to find specific cases on this point, but the general principle is that once an expert is designated, their work becomes discoverable. You can't draw a line in the sand in the middle of that expert's work and say that the work product privilege applies before some date, and after that date, no privilege applies. Everything the designated expert witness has done in the workup of the case is discoverable. Nothing is shielded from disclosure to the other side. So caution to experts here. A retained, non-designated consultant must be mindful of the fact that, if he is later designated, his knowledge and analysis will be exposed from the beginning of his work in the case. Whatever the consultant has learned about the issue in question, particularly if it's negative, should help inform the decision whether or not to formally designate the expert in the matter. A second nuance to the expert privilege issue is the notion that one employee of a firm can be a designated expert witness and another employee of the same firm can be a consulting expert. This is not a tenable position. In the area of professional conflicts and confidential information, the knowledge of one employee of a firm is attributed to all members of the firm. So, one employee's knowledge can't be shielded from discovery, while another employee's knowledge, the expert's, is not. In summary, from the perspective of the designated expert witness, you should assume that nothing you do in a case is privileged. You will have to disclose all research, communications, preliminary analysis, everything you have done to the opposing side in discovery. Don't ever let a client assume that communications with you are subject to the attorney-client privilege. They aren't. Be assertive in taking control of any conversation that expands beyond your area of expertise, and advise your lawyer-client and ultimate client that conversations with you are not privileged. Be careful not to spoil your otherwise good work in a case with strategic discussions with your lawyer-client that'll have to be disclosed to the other side in discovery. I cover all the areas of operating and managing a forensic consulting practice in my treatise, Mastering the Art of Expert Witness Testimony, as well as strategies and tactics for testifying in expert depositions, direct examination, and surviving cross-examination. My book is available on Amazon, and I assure you, it's worth your time.
Brian Peter Brinig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon.